Well, Henshaw here again, Constitutional Crisis Channel. And I've done videos on this case before, and I may have one or two on it afterwards, called Cohens, Cohens versus Virginia, which is 6 Wheat 264 or 19 US 264. And this is the case that if you look at it carelessly in the volumes, you're going to see it runs about 180 pages, which it does. But the decision itself is fairly short. And this is a good point to make with these what you might call vintage cases. This is 1819, I believe, when it was decided. And cases of that type, and especially important cases, which this was, the court would often report the entirety of the arguments for counsel on both sides of the case. And you can learn a lot from reading those, which I encourage you to do. I do it myself. And in this case, that's important to do because you'll see what they thought to say the law was on both sides. You can look at the past authorities and make your own decisions. But this case is so good because, among other things, Chief Justice John Marshall, who is that infallible icon of Cambridge and New Haven, Harvard and Yale, was never wrong. There's a better record for perfection than the Pope in Vatican City. And he said, talking about states that discharge obligations by using paper money. And he said, in effect, this won't be the exact quote, but I'll get it for you. It'll be in the notes below. You can read it. But he said, in effect, that discharging the obligation was a mere nullity, and the debt is still due. This is a shorthand way of saying, and I'm a little bit premature because I don't have the document done for this yet, but trust me, I will soon. You'll hear about it. Because if that's right, and it is right, this is how you get around the IRS, because they think that your receipt of obligation with these Federal Reserve notes, which are nothing at all but credit money entries created by the Federal Reserve. I mean, that's Manor F. Eccles in the damn hearings before the House Subcommittee on Banking and Finance, 1941. There's nothing behind them. The courts, the banks, and nobody else recognizes this as any property interest whatsoever. They just don't. You get paid in gold and silver coin. That's specie. That's property. And now the argument against the IRS and the FTB and whatever is that that's the taking of property without judicial process. That's a bill of attainder. The federal government can't do it. The quote-unquote state governments can't do it. And I'm at a loss to see a way how to get around that. I mean, that's dead bang. And especially if at one and the same time we're arguing, as I now do with my special brief on the 14th Amendment, that those of you that get my document packets are going to see, that establishes the unconstitutionality of the 14th Amendment. Now the government can't use any of the fictions of law associated with that amendment to try to rein you into the system and make you a taxpayer. It doesn't work because the only taxpayers are the ones who do owe their citizenship to the 14th Amendment, if it exists. And as Hugo L. Black said in his remarkable dissent in Connecticut Insurance v. Johnson, 303 U.S. 77, you'll get that on the bottom, and he indicated exactly what the secret intent of that amendment was, which was to make citizens out of corporations. Now, we start throwing issues like that up against these bastards, and especially we do it in judicial courts, not the Article 1 tax court, which is a legislative tribunal, not what looks like Article 3 federal district courts, because the federal rules of civil procedure stipulate that there are no longer any judicial courts under Article 3 as far as Title 28 is concerned. You don't go there either. It looks like we don't have federal circuit courts, which we did up until 1911. Those were judicial courts. Now we have federal circuit courts of appeal, which for reasons I'll discuss more fully in a later video, aren't anything close to judicial courts. And I think incoming Justice Gorsuch found that out the hard way, a subject matter for another day as well. But I found that part very interesting in his confirmation hearings, which were otherwise so dull you can't stand it. But this is where you go after them and get them, because if we're not entitled to judicial courts, then they're saying, in effect, that Congress has legislated out of existence at least Article 1, Sections 9 and 10, the 9th and 10th Amendments, and who knows what else out of the Constitution, which they can't do. They would have to do that under Article 5, the amending process, And you can look in vain if you can find where they've done that under Article 5 and amended those provisions of the Constitution out of effect. Could you please tell me? I can't find it in my copy of the Constitution anywhere. This is how we beat the bastards. And now you take home every dime you earn. And that's exactly what should be happening. That'll make us all a hell of a lot better off. You'll still certainly be subject to some taxation that the government can impose, although the de facto government, as far as I'm concerned, has no power in that area. But they can't do it on your property. And even worse for them is if they would tax your property, that's a direct tax, which Congress can't do without apportionment among the states. Now, my documents, and those of you that get my packets are going to see it, and send me emails about that, ccaspary@live.com, CCASPARY, about my document packets, and you're going to see that my record over the course of 4 decades and 20 straight wins has established that there is no 14th Amendment. Now, if that's the case, as I say, they can't use the citizenship thing against you, and even worse, if they're going to say that it does exist, they have to make the argument that there are no states. Now, without any states, how can there possibly be any apportionment among the states to support a direct tax? Bam! Doesn't work. No matter which way they turn, I have them, and so will you. And we get these documents out there. And that's, by the way, is why I'm pushing so hard in traffic court, because once we get these principles established there, they're good across the board. And the Supreme Court is going to choke on their own binding precedent if they have to. I would love to see that happen, because it applies across the board. It is what it is. If there's no judicial courts, no judicial process, we win. They lose. Simple as that. Thank you.